Have you ever stopped to consider if there are moments when deliberately and publicly breaking a law isn't just an act of protest, but rather a profound statement about the very nature of our duty to the state? It is a truly fascinating and essential question that deeply explores the intersection of individual moral conscience and the frameworks of collective governance. Civil disobedience challenges political obligation by asserting that a compelling moral or ethical duty can, under very specific and carefully considered circumstances, ethically override a legal duty. It directly questions the fundamental assumption that citizens always possess an unconditional and absolute obligation to obey every single law, even those laws that are widely perceived as profoundly unjust or ethically wrong. The core of this challenge lies in the intricate and multifaceted nature of political obligation itself. Political obligation, in philosophical terms, refers to the moral duty that citizens are understood to have to obey the laws and the legitimate commands issued by their government. Throughout history, philosophers have presented various theoretical foundations to explain and justify this obligation. For example, social contract theory proposes that we implicitly or explicitly consent to government rule, forming a social contract, in exchange for the protection of our rights and the benefits of an organized society. Another perspective is the principle of fair play, which suggests that because we benefit from the cooperative endeavors and stability that a legal system provides, we then incur a reciprocal duty to uphold and obey its laws. Civil disobedience, however, posits that when a particular law or a series of laws fundamentally violates deeply held universal moral principles, or when the government itself acts in ways that exceed or betray its legitimate authority, the very basis for this political obligation becomes significantly weakened or even entirely dissolved. It is crucial to understand that civil disobedience is defined as a deliberate, public, and nonviolent act of breaking a specific law or policy, carried out with the express intention of bringing about a meaningful change in that particular law or policy or the underlying government action. A distinguishing characteristic is that the disobedient individual, through their actions, implicitly acknowledges the overall legitimacy of the legal system by openly accepting the prescribed penalty for their transgression. In doing so, they affirm their broader respect for the rule of law as an institution, while simultaneously and specifically challenging a particular aspect that they deem morally unacceptable or unjust. This philosophical understanding of civil disobedience offers us invaluable tools to analyze and interpret pivotal historical movements for social and political change, ranging from the non-violent struggles of the civil rights era to various independence movements across the globe, where countless individuals and groups deliberately chose to prioritize their moral convictions over strict legal compliance. Furthermore, it provides a robust conceptual framework for thoroughly examining the dynamic and often contentious relationship between the coercive authority of a state and the deeply personal moral conscience of an individual. This analysis yields significant insights into the intricate ways societies confront systemic injustice and continuously evolve their understanding of fundamental rights and corresponding duties. When we delve even deeper into the theoretical underpinnings, we encounter crucial concepts that illuminate this debate. For instance, the idea of a prima facie obligation refers to an obligation that is binding at first glance or on its face, but one that can be overridden if there exists a stronger, more compelling reason against it. Proponents of civil disobedience frequently argue that their profound moral duty to challenge perceived injustice provides precisely such an overriding reason. This philosophical stance often resonates with the ancient maxim lex injusta non est lex, which translates from Latin to mean, an unjust law is not a law at all. This powerful idea suggests that a decree lacking fundamental moral grounding may carry no genuine moral weight and, consequently, should not compel moral obedience or political obligation. It is also vital to distinguish civil disobedience from mere ordinary criminal acts. Its ultimate aim is never personal gain, nor is it to subvert the legal system entirely. Instead, it is a meticulously calculated and public appeal to the wider community's collective sense of justice, strategically designed to initiate meaningful public dialogue, encourage critical self-reflection within the state, and ultimately lead to substantive policy reform. Ultimately, a thorough exploration of civil disobedience profoundly illuminates the enduring tension between individual moral autonomy and the necessary demands of collective living under a structured legal framework. It powerfully reveals that political obligation is not, and perhaps should not always be, an absolute or unwavering mandate. Rather, principled and conscientious resistance can serve as a potent, albeit exceptional and carefully considered, mechanism through which societies courageously confront and diligently rectify fundamental injustices, thereby continuously reshaping and reinforcing the ethical foundations upon which all governance ideally rests.